The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. I want to welcome everybody to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. The first is 22-7199, Anderson versus Ferguson. Ms. Stetson, you have a introduction to make?
Good morning, Your Honors, and may it please the Court. My name is Kate Stetson. I am here this morning in my capacity as a supervisor of the University of Virginia School of Law Appellate Litigation Clinic, and it is my pleasure to introduce to you Ames O'Boyle and Anthony Valdez, who will be presenting argument as court-appointed amicus. Thank you.
Thank you very much, Ms. Stetson. Mr. O'Boyle, whenever you're ready, sir.
Thank you, Your Honor, and may it please the Court. My name is Ames O'Boyle, and my colleague, Anthony Valdez, and I were appointed by this Court as amicus on the excessive force issue.
You might want to move that mic, to the extent you can, a little bit closer, up closer to you.
How's that? Any better?
We'll give it a shot. Go ahead.
This case is here on appeal from a grant of summary judgment. A core factual issue is whether Mr. Anderson was resisting and posed a threat when Officer Ferguson used the mandibular angle pressure point against him. The officers submitted affidavits saying that Mr. Anderson was resisting, but the video footage in the record appears to conflict with that characterization. When properly construing the video at this stage of the litigation and making all reasonable inferences in Mr. Anderson's favor, genuine issues of material fact exist, and a reasonable jury could find that Officer Ferguson's use of mandibular pressure constituted excessive force.
So before we get into Officer Ferguson, can I just make clear something I think is pretty clear from the briefs? We are only talking about the district court's grant of summary judgment as to Officer Ferguson, right? We're not challenging the district court's order as to the other people who were named as defendants?
Correct.
Okay.
As to the other people named as defendants, there is the denial of leave to amend issue as well. Against
Sure,
them.
but not in terms of the grant of, on the existing record as to them. Okay.
That's correct. Now, Graham v. Connor directs our attention to three factors: the severity of the crime at issue, whether the suspect poses an immediate threat, and whether the suspect is actively resisting or fleeing arrest. And this court has been clear that in considering the reasonableness of the officer's actions, we need to consider the facts at the moment that the challenged force was used. So I'd like to take a minute to be clear about what the facts at the moment show here. Mr. Anderson was face down on the ground with his hands tightly handcuffed behind his back and his pants and underwear down around his ankles. Officer Ferguson was holding on to his hands, and Officer Wagner was holding on to his elbow. Over the span of just 5 seconds, Officer Ferguson twice tells Mr. Anderson to stop resisting while pulling him up by the back of his jacket, and then forcefully drives his thumb into Mr. Anderson's mandibular nerve for 9 seconds.
So can I ask you about that sequence of events? And you're relying obviously on the video in describing what happened here?
That's correct.
Okay. So in the district court, when Mr. Anderson was objecting to the magistrate judge's recommendation, he submitted it, he was pro se, right, at the time.
Correct.
And in paragraph 55 of that objection, he said this: during the existence of plaintiff's insanity, and it appears obviously that Mr. Anderson has some mental health issues, and so he says that as a prelude. He then says, plaintiff begins to continue rocking back and forth before Officer Ferguson yells, "Stop moving." And didn't I say to stop effing moving? Okay, so Do you agree that in addition to the video, we're supposed to take the entire record in deciding whether or not there was a violation, first of all, and then deciding whether or not to hold this officer liable as a matter of qualified immunity? Do you agree with that?
I agree with that, Your Honor, but I actually don't think that his statements there were an admission that he was moving. When you look at his objections pertaining to the use of the mandibular angle pressure point, he almost entirely quotes from statements by defendants and the district court. And I think when you compare his objections in paragraph 55 and the beginning of 56 to what the magistrate judge says at JA 162, I believe, it's clear that he is quoting the way that the district judge characterized it.
Why is it clear? Why is it clear to you?
It's almost identical language.
Okay. And in what context is that paragraph being offered?
Paragraph 55
Yes.
or the...
Right.
I think what Mr. Anderson does often when you look at his mandibular objections is that he quotes other language that was used in an attempt to disagree with those characterizations. And I would also, point your honors to his initial complaint at JA 16 and 17, where he does say that he was clearly not resisting or a threat in any way.
Is there a difference between resisting, well, obviously there is, between resisting and moving? Do you concede that he might have been moving?
Yes, as well, Your Honor. That just, his movements don't necessarily mean that he was actively resisting. And we think that there is a question of fact as to, how far, whether his movements arise to the level of resistance and whether Officer Ferguson's perception that he was resisting was a reasonable perception.
So just to clarify, that you anticipated the thing I was about to ask. The question, right, is not under the Fourth Amendment, not whether he was in fact resisting in his own head. It's not even really whether he was in fact resisting to if we had the God's eye view with perfect knowledge of everything that was happening, whether he was actually resisting from that perspective. The question is what a reasonable officer in Officer Ferguson's position could have perceived at the time is the actual question, right?
That's correct, Your Honor.
So a real example, say it's not in fact a volitional movement, so it's not in fact resisting arrest for criminal law purposes or anything like that, but if the officer believed it was, that could matter for the Fourth Amendment analysis. Whether a reasonable officer could have, because of course things under the Fourth Amendment, it is not also actually what the officer himself actually thought. It's what a reasonable person in the officer's position could have reasonably thought.
Absolutely, Your Honor. And the video footage here, the uncertainty in it, we think, creates a genuine issue about whether that perception that he was resisting was a reasonable perception. Now, the video is not entirely clear. So when we watch the video and make reasonable inferences, it does appear to show that he is not actively resisting, and at worst, he is slightly squirming or rocking under the weight of the officers on top of him. In addition, I also want to point out the conduct of the other two officers. At some point, while this encounter is going on, Officer Wagner moves his hands to casually rest at his sides, and Officer Phillips turns his back and begins walking away from the scene. Now, the district court correctly held that the first factor weighed in Mr. Anderson's favor because his crimes were minor.
Can I ask you, the behavior of the other officers, I think I understand why you think that's relevant, but could you just articulate a little bit more why the hands at sides walking away, why does that matter?
On the second factor, whether Mr. Anderson is a threat, the conduct of the officers there indicates that they did not legitimately perceive him to be a threat. And I would point to this court's decision in Sawyer v. Ashbury, where the court said, the conduct of the two deputies is a powerful indicator that a need to deploy violent force was not apparent to a reasonable officer.
So just again, the fact that two other people acted in ways that suggested they didn't think he was resisting or a danger is indirect evidence that a reasonable officer in Officer Ferguson's position could not believe that he was a danger. That's the sort of chain of reasoning?
Correct, Your Honor.
Okay.
And, in addition on this second factor here, so the district court believed that he was an immediate threat because he was reasonably believed to be armed and because it said he was resisting. But this court has said that an armed but handcuffed suspect poses little, if no, threat, and the reasonable inference we make is that he was not resisting. The totality of the circumstances at the moment also show that he was not a threat or an immediate threat because he was secured both by handcuffs and multiple officers. Then on the third factor, at the moment force was applied, he was no longer fleeing, and as discussed, there's a question of fact as to whether he was resisting. So Officer Ferguson's use of mandibular pressure when we make reasonable inferences in Mr. Anderson's favor was excessive and objectively unreasonable.
Is the extent of the force at all relevant here in response to what you concede at least was movement, if not resisting?
The extent of the force and say any injuries that arise from it are relevant, and I would like to point out that the mandibular pressure point is a serious, pain compliance technique that puts substantial pressure on a nerve ending and is incredibly effective at getting resisting suspects to comply with orders. And I'd also point to the Sixth Circuit's decision in Lunine, which said that the mandibular pressure point is a substantial, pain compliance technique that can cause asphyxiating conditions. Now, on the clearly established prong, this court and Supreme Court have reaffirmed that we don't need a case dealing with 100% identical facts, but the principles and direct holdings of multiple of this court's cases repeatedly and distinctly establish the principle that it's excessive to use unnecessary, gratuitous, and disproportionate force against a suspect who is secured, not a threat, and not resisting. I'd like to quote from a few of this court's decisions.
But would it have been clear to Officer Ferguson that he couldn't use this minimal level of force, granting that you say that it's pain compliance, it can be quite painful in the circumstances, but given the fact that he had issued a command for Mr. Ferguson to stop moving, and he perceived, if not actually understood, that Mr. Anderson wasn't complying with that command, that this minimal, in the scale of things, of the force that could have been applied, this level of force, is it clearly established that the officer could not have used that level of force to gain compliance in order to have Mr. Anderson adhere to the command to stop moving?
Your Honor, on summary judgment, when we make all these reasonable inferences for Mr. Anderson that he was not resisting.
Well, we're accepting those facts, but I think you also have to accept the fact that there was at least some movement. Is that relevant here?
Well, and Your Honor, I would respectfully disagree that there, is at least some movement. I think when you watch the video from approximately 1:37 to 2 minutes, it quite plainly shows Mr. Anderson is not really moving in any
I
substantial
thought you told
way.
us earlier that he was.
If the court believes that there is some movement, that doesn't necessarily, mean that the force was automatically justified. It doesn't automatically mean that he was resisting.
No, but it might be relevant to the clearly established question.
Yes, Your Honor.
Okay, so you're not conceding that he was moving, you're just suggesting that even if he was, you still don't think that an officer in Officer Ferguson's position would have understood clearly as a matter of law that he couldn't use this, again, in the grand scheme of the force scale that could have been applied, this level of force to gain compliance. That's your position?
Yes, Your Honor. And, the very summarized answer here is that this court's cases focus substantially on whether a suspect poses a threat and whether they are actively resisting. And this court has said, for example, in Jones v. Buchanan, when it characterized its earlier decision of Kane v. Hargis, the court said that, quote, "It would have been apparent in 1990 to a reasonable officer that his use of force, when he pushed the woman's face into the ground, was excessive because after the officer had secured the plaintiff, she did not pose a threat, and any additional use of force was unreasonable."
Can I ask you, with your remaining time, to say a little bit about the leave to amend issue?
Absolutely, Your Honor. 2 points on this issue. One is that the court was clear in Nicholson v. Medcom that, quote, "It is an abuse of discretion for the district court to fail to identify which of the 3 permissible reasons it relied on." And I'd also like to point out, in Appellee's brief on page 51, they cite James v. Jacobson for the proposition that for there to be abuse of discretion, the court must find a failure or refusal actually to exercise discretion. And I think that citation omits crucial context, because the full quote states that abuse of discretion can occur in a number of ways, and that a failure to exercise discretion is one manifestation of abuse. But, quote, "Another way, crucial there and here, is by failure in attempting to exercise discretion adequately to take into account judicially recognized factors constraining its exercise."
So with respect to that issue, what would have been the claims that your client would have lodged against the other officers? I mean, it seems like he lodged a series of fantastical claims that turned out to be completely rebutted by the videotape evidence. And if we find that to be the case, and if we're inclined to, as we should be, I think, to affirm the district court on any reasons apparent in the record, why isn't futility a ground to reject this claim of a motion to amend?
And, you know, the court in MedCom said that if you believe the district court's reasoning was apparent, it's not an abuse of discretion. But I can't speak to all the claims he might hope to assert, but I think the core claim against these other two officers is the claim about sort of the sexual assault or searching his butt. And the video is obscured for approximately 12 seconds, 15 seconds by Officer Ferguson's hands. And we think that that obstruction and the inability to see what happens means that it is not a futile claim as a matter of law. I see that I am out of time.
All right, thank you very much.
Thank you.
Mr. Morgan?
Thank you, and may it please the court, I'm Jim Morgan. I'm here representing the officers, and we'll just focus on Officer Ferguson. Before I go any further, I'd like to introduce the Winston-Salem City Attorney, Angela Carmen, who's sitting right there. And I've been working with her for 20-some years, and she came up here to support me. And the lady sitting beside her is Camille French, who will be the new city attorney come January. So I just wanted to make that introduction to the court. Your Honors, the only claim being pursued for purposes of this appeal is what I call a new claim for excessive force against Officer Ferguson in his individual capacity based on his brief use of an accepted and recognized law enforcement technique that we call the mandibular angle pressure point technique, which I'll probably just call pressure point technique from now on. First of all, I would like to just point out what was pointed out in filings with this court, and that is that the plaintiff has waived appellate review of this particular claim because he failed to file specific objections. If you read...
Mr. Morgan, can I ask you as a threshold? You say that we should dismiss the appeal because of that.
Yes.
Have you been able to identify any case where we have dismissed the appeal for failure to adequately object to a magistrate's report? It feels like we just affirm, not dismiss the appeal.
Well, maybe I read the case wrong. I cited a case in there where I believe that the appeal was dismissed. But yes, if you affirm it, you get the same result.
Okay.
I think in the case of U.S. versus Midget, the holding was, we hold now that to preserve for appeal an issue in a magistrate judge's report, a party must object to the finding or recommendation on that issue with sufficient specificity as reasonably to alert the district court of the true ground of the objection.
Okay, but we also have had two published opinions that I'm personally aware of in the last year and a half in which we have emphasized that particularly as it relates to pro se litigants, that is a low standard, right?
I hear what you're saying, Your Honor.
Like we've reversed district courts who have basically found things were forfeited on the grounds of, this is not a questions presented like in a Supreme Court brief. This is not like that. You can just say, I think the magistrate judge was wrong in concluding there wasn't excessive force here, and that's basically enough.
Well, Your Honor, the cases that were cited by the plaintiff, as I put in my brief, they're distinguishable because in those cases, the pro se plaintiff actually mentioned the issue.
Well, doesn't he mention the fingernails behind his ear and the thumb or something behind his ear?
I think there was a reference somewhere to a thumb behind the ear before he was handcuffed.
JA 17, doesn't he say that in the complaint at JA 17? Sorry, not in the complaint, but
I don't remember the site, but I believe in the complaint he talked about fingernails behind the ear.
Stuck his fingernails behind my ears as I got handcuffed. Does that sound familiar?
And that sounds familiar. I would say that I'll just put it this way. I won't belabor the point. If you read the objections of the plaintiff, I believe you should conclude that he did not object to the mandibular pressure point technique at all. He reiterated his belief that he was sexually assaulted, which, as you say, was fabricated. He talked about the chokehold. He talked about getting knocked off the bike. But if you read the objections about the mandibular pressure point technique, what you find is him saying it was an accepted law enforcement technique. If the standard is that the court is supposed to be on notice that this was an issue, those objections did not put the district court on notice that that was an issue. And I would just submit to you that, in my opinion, as an officer of the court, you would have to rewrite the objections in order to conclude that, that he preserved that issue. But I'll get on to the next part. I think that's adequately argued in the briefs.
So, because I suspect we're about to get into the merits of the Fourth Amendment, can I just take you to the leave to amend issue for just a second, because I only have like one or two questions about that? Sure. In what way was the district court's denial of leave to amend premised on bad faith, prejudice to the non-moving party, or futility? Because when I read the district court's explanation for why it denied the leave to amend, it does not identify any of those three reasons. And I think we've said those are the only three valid reasons for denying leave to amend.
I think you can conclude that futility was the reason, but what I said in our brief is I emphasize that it's a discretionary.
No, it's not discretionary. We've said district courts do not have discretion to deny leave to amend except on those three grounds. There is no discretion to add a fourth ground.
I would say this, the video shows it would be futile.
Okay.
And the court can do,
Sure.
you make
Okay.
your ruling on that.
I think that was my only question about that.
Okay, great. Officer Ferguson moved for summary judgment. He supported it with an affidavit and an authenticated body cam video. The plaintiff didn't file affidavits. The plaintiff did not file any evidence. The plaintiff, in his response to summary judgment, didn't mention the mandibular pressure point technique, even though it was brought up in our summary judgment brief, because it's right there on the video. The rule that the Supreme Court has articulated is a plaintiff cannot defeat summary judgment by simply asserting the jury might disbelieve the plaintiff. The plaintiff can't rest upon mere allegations or denials in his pleadings. The plaintiff must produce specific evidence rather than resting upon bald assertions. And I would submit to you that because of the posture of this case, this isn't a case where the plaintiff gave one affidavit and the defendant gave another. So you don't look at whether the video is unclear. If it's unclear, then you've just got a disputed fact, just like any other case. This is a case where only one side gave evidence, so what you look at is, does the video blatantly contradict that evidence? The answer is no, it doesn't. And in
Wait,
fact-
we asked whether the video blatantly contradicts what the defendant says?
Yes,
What
because-
case says that?
Well, I cited the case Sawyer versus Asbury.
Like, I understand Scott versus Harris says if the plaintiff, the party opposing summary judgment, so take a step back. Normally speaking, if the party opposing summary judgment files an affidavit saying that this is what happened, you have to credit that for summary judgment. Scott versus Harris says, well, except when there's a video that literally blatantly contradicts everything the plaintiff says, then you can disregard it. But I'm not aware of any case that says, in situations where the plaintiff doesn't submit an affidavit but the defendants do, the question is whether the video blatantly contradicts what the defendants say. I don't know any case that has applied Scott, well, let me rephrase. I don't know any case that is controlling on this court that has applied Scott versus Harris in that way.
Most cases applying Scott versus Harris deal with the situation where two sides give different.
Right, and then we say we can disregard the non-moving party's affidavit. Totally fair. But I don't know any case that talks about in situations where the moving party's affidavit does not blatantly contradict the video, you have to assume the non-moving party is telling the truth.
Well,
Sorry, the moving party.
in Sawyer versus Asbury, the statement was, video controls only where it blatantly contradicts, and then it uses the term testimony. Yes,
Yes, the testimony from the party
was-
opposing summary
It
judgment,
was
not the party's.
talking about, in that case, it was talking about the plaintiff. That's
Right, which makes total sense, because Scott versus Harris is a narrow exception to the general rule that when the plaintiff says X, you have to believe him for summary judgment.
But in this case, we have a situation where the plaintiff did not say anything.
Totally agree.
And what the plaintiffs are trying to argue now is that because there's a video that doesn't show every single thing that happened, you have to conclude, you have to, in essence, it's really the same, to me, it's the same as the summary judgment standard.
Why doesn't
that
it mean
was-
we have to construe the video in the light most favorable to the plaintiff?
I would just say, my argument is that if the video doesn't blatantly contradict what Officer Ferguson said, then the video is irrelevant for summary
Turning the
judgment
summary
purposes.
judgment standard on its head. I mean, we're supposed to construe the evidence in the light most favorable to the non-moving party. That means all of the evidence, affidavits, video, whatever happens to be in the record, right?
In the situation where one party testifies, if there were no video, you wouldn't say, well, there's no video, so it's unclear what a video might have shown. Here, you've got a video that supports what, I would say supports what Officer Ferguson says.
Well, that's a different argument, I suppose, but they say otherwise.
Well, let me move to that. The plaintiff in his brief, appellant's brief said there was squirming and movement right before the mandibular pressure point technique was used.
Can I ask you, before you get to that, about the objections that he did file? Because, you know, when I first read that paragraph 55, I thought that was a statement of fact that Mr. Anderson was making about conceding essentially that he was moving, but your colleagues on the other side say, no, 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 he's just reciting what the magistrate judge is saying about the record. So what's your view on that?
Well, if you look at the objections, there are a bunch of them. And where the plaintiff doesn't agree with the magistrate, he's real clear about that. He says, the plaintiff says in his objections, I was sexually assaulted. I was knocked off the moped, and that was excessive force. I was put in a chokehold until I passed out. He says things like that. That's not something the magistrate said. The magistrate said he was rocking right before the mandibular pressure point technique was used, and the plaintiff recites that. I would say that's a concession that that's what happened. And in fact, if you look at the video, the magistrate and the plaintiff both recognize what I recognize, that he was moving right before.
So this argument that's been made regarding moving and resisting, wouldn't that be a issue of fact?
No. No, in the qualified immunity analysis, you have to find the case that, or cases that establish a bright line, that exactly what Officer Ferguson did crossed the bright line. That's what
Well,
qualified
we would have to
immunity is all
accept that
about.
he was moving, not resisting, and then say that even though he was simply moving and not resisting, Officer Ferguson wasn't on notice that he couldn't apply this technique in response to that movement, right?
Officer Ferguson perceived that he was resisting by pulling away. The video shows he was moving, which supports Officer Ferguson's reasonable perception. There is no case that says in a situation like that you can't use this minimal level of force. Officer Ferguson, here's what Officer Ferguson did not do. Officer Ferguson did not tase him. He didn't whack him with his fist. He didn't injure him. He simply used the mandibular pressure point technique. He didn't put a chokehold on him, which plaintiff repeats that he did. He did not. And he did it for 9 seconds and then stopped. So there is no case putting anyone on notice that that would violate the Constitution. In fact, there were at least 2 cases that I cited, one from the 8th Circuit and one from the 10th, I think, Jews, and the other one, that suggests that in situations where a plaintiff was doing much less than what, or much more rather, more force was used in the Jews case and I think it was the Pride case.
So I don't know if this helps him on the second, what I will call the second prong, well, I don't actually, the clearly established prong of qualified immunity. I don't think this case helps him necessarily on that because of the timing issue, but doesn't our decision from last year in Lewis also involve a situation where a suspect was moving and say that is not dispositive to whether there was a Fourth Amendment violation?
Which case are you talking about, Your
Lewis?
Honor? Lewis,
Portoballo?
the one that was cited by plaintiff.
Wasn't the guy moving in that case?
Lewis was in a completely different procedural.
Sure, but that is a case in which someone was moving, and we said just because he's moving doesn't mean what you're doing is fine. Doesn't mean it doesn't mean that there is necessarily no Fourth Amendment violation simply because someone is moving. Lewis very clearly rejects that proposition.
That's true, but I'll flip that on its head a little bit. The plaintiff suggested that if you're restrained, no force can be used. Well, that clearly is not the case. You always have to use force on a suspect. If, for example, he doesn't want to get in the police car, you have to force him to get in the police car. If he doesn't want to be fingerprinted, you have to use some level of force to get him fingerprinted. In this case, some level of force, if the reasonable perception was that he was not complying with legitimate commands to stop moving so that he could be searched, some level of force would be reasonable. And in this case, it was an extremely low level use of force, extremely low level, mandibular pressure point technique. He was not hurt. Yes, it's true that there was a case in the Sixth Circuit where so much force was used, including the mandibular pressure point technique, and the guy ended up asphyxiating and dying. This is not such a case. That case has no application here because we're talking about a 9-second use of the pressure point technique. There is no case putting Officer Ferguson on notice.
How do we know
that
it's a
violates the
9-second?
Constitution.
You're just asserting that it's a 9-second use of a specific technique that we know is constitutionally okay. How do we know any of that, other than the say-so of the defendant?
How do we know what the facts
That it was a proper application of the mandibular. Like, for example, he does allege in that objection we talked about, like, sticking a finger in my ear. Is that how one applies the mandibular technique if one is doing it correctly?
Officer Ferguson stated in
I'm
his
not
app-
asking what Officer Ferguson said, I'm asking what the plaintiff has asserted. Is it a proper application of the technique to stuck his fingernails behind my ears? Is that?
You're talking about the complaint?
No, I'm talking about his objections to the magistrate. I guess my point is, in describing what happened here, it seems to me that you're simply describing what the defendant says that he did, as opposed to what the most charitable interpretation to the plaintiff under the video is of what the defendant did. And I think that's the way we have to think about this for summary judgment.
You can see on the video he's doing this.
Okay.
You can see that.
Okay.
That's what he said he did, that's what the video showed. You can see that part pretty clearly.
And I guess you could watch the video and you could count how long you
That's-
could
yeah,
potentially count how long it lasts.
That's what I did. The magistrate said 9 seconds. I counted it myself. I came up with 9 seconds. I think the plaintiff in their first brief said 10 seconds.
What do I do with the fact that on the video he says he's still in pain 8 minutes later? That undercuts a claim that it was just this kind of force that hurts like heck when it's on, but then it goes away afterwards. The fact that this guy says on the video that he's still in pain 8 minutes later suggests that maybe it was something different, because if he's in pain 8 minutes later, if I'm told that a proper application of this technique should not be painful after the technique stops, and on the video he says, I'm still in pain 8 minutes later, that's at least some evidence that maybe it wasn't that technique.
The video, or at least either affidavit or the video or both, also shows that he was released by the EMTs as needing no further medical attention.
Sure.
A lot of cases that this court gets and other courts get, you've got a guy with a broken leg, a broken arm,
Sure.
head injuries, et cetera, et cetera. Here you've got what amounts to the lowest level of force that almost one of the lower level of forces. How's that? Not the lowest level, you're right. But a very low level of force, comparatively speaking. I've had cases in my career, and this court has seen cases where people are horribly injured, people have broken bones, people have internal injuries. This is not such a case. The guy walked away from it.
But why doesn't that more go to damages, if any, that he could get, rather than what? Like, let me ask you this question. I'm going to posit that you don't agree that the facts show this, that the defendant says this isn't what the facts show. But do you agree that it violates if a suspect is in fact completely subdued and poses no immediate danger to any officer, and no officer could believe that he poses any immediate danger to any officer, any de minimis amount of force is excessive?
I believe that's what the cases hold. If under your posit, but that's not.
No, I understand. You don't. But we do. But I guess my point is, and do you claim that this technique is a de minimis use of force as a matter of law?
I don't claim that. What I claim is there's no case that puts him on notice.
No, sure, that's prong two.
That in this
I'm at prong
specific
one.
situation, it violated the Constitution to use that pressure point technique.
Okay, but so my point is, maybe for the sake of argument, we could say there is some amount of force that is just constitutionally de minimis. Like, there's that language in Graham versus Connor that says, like, not every push and shove that may look fine later, fine. Not every push, not every shove. And that suggests that maybe under some circumstances there's a de minimisness before the Fourth Amendment gets involved. But you don't claim that using this technique is below whatever that level of de minimisness is.
I haven't really given it any consideration.
Well, I guess, to gratuitously use this
I think
technique
you're probably
against
right, Your
somebody
Honor. Yeah,
violates the Fourth Amendment.
I think yes, I think you're right. But in this case, that's not what happened.
Right. Understand, that's not right.
And I'll just reiterate, because I think this is the crux of it. Officer Ferguson, in order to lose the cloak of qualified immunity, had to have.
Well,
there
but
had
you
to
keep
have
saying
been a-
qualified immunity. The district court actually found there was no constitutional violation here, right?
Well, we argued qualified.
No, I
immunity.
understand you argued it, but like the decision that we're reviewing is a decision that says there isn't even a constitutional violation. And every time I ask you about that, you pivot to prong two, which is not a concession, but I guess it's noteworthy that every time I ask you about the constitutional violation question, you pivot to clearly established.
What it means is that is the prong that we clearly went on. That's why I pivot to it.
Okay.
Was there a constitutional violation? No. But if there was, it wasn't clearly established. And I know that this court has said that the defendant officer has the burden of proof, but I will point the court to Rivas Villegas versus Cortes Luna, a Supreme Court case in which the Supreme Court said, when discussing the second prong, Thus, to show a violation of clearly established law, plaintiff must identify a case that put the officer on notice that his specific conduct was unlawful. That's what the Supreme Court said. That suggests that the burden's on the plaintiff. But no matter who the burden is on, it's been met here. There's no case, there's no bright line that says that Officer Ferguson could not use the pressure point technique under the specific circumstances of this case. So, Your Honor, my time's almost up. It's been a pleasure as always. This is like the 35th anniversary of me being here for the first time. So I've been here a few more times than my colleagues on the right. I would ask the court to affirm summary judgment and to deny the motion, and to affirm the deniance of the motion. Thank you very much.
Mr. Morgan. Mr. Valdez?
Good morning, Your Honors, and may it please the court. Anthony Valdez, here as amicus. I wanted to start out my rebuttal by just pushing back on the characterization of the mandibular angle force technique as a minimal level of force. I mean, this is a pain compliance technique designed to stop suspects from thrashing around using only a thumb. It is that powerful that you can put your thumb behind and pinch somebody's nerve that it will stop you from doing whatever you need to do. And Officer Ferguson used that technique while bearing his whole weight down on Mr. Anderson.
What injuries does your client allege that he had as a result of the technique being used?
You know, I would want to go back into the record. One, I guess we're here on amicus, so just not our client, but I believe he mentioned injuries to his face from the whole encounter. I think, as Judge Heitens pointed out, the extent of those injuries might limit his damages in some way, but that would be for a jury to decide as to the extent of those damages, and he would also need to parcel out.
Right, but one of the relevant Graham factors is the nature of the force and, you know, the impact of that. So I think that's a relevant question. So, and you started out by saying, well, this is terrible. And I guess in the abstract it is, but was it in this case?
I believe so, Your Honor. I mean, as Judge Heitens referred to, during the encounter, Mr. Anderson, and this is captured on video, mentioned several times that he was in pain after. He talks about.
Well, didn't he say his face hurts, which would have been from the fall on the ground, and that his head is hurting from the braids being pulled out?
He does say that his face hurts. I don't know if he was making, the record is unclear at this point about whether or not that was due to the fall, but I think it's very likely that it was also due to the fact that you had a thumb pinching into his nerve, a pain compliance technique so powerful that it can stop a suspect from totally resisting. And I think the important thing is that pain compliance technique was used on somebody who was handcuffed, face down, his pants on the ground, with multiple officers on top of him. Just very quickly on the leave to amend issue, there was some discussion about whether or not this was denied on futility grounds. At JA 5, which is the text order denying leave to amend, there's actually 4 things that Mr. Anderson tries to amend his complaint about. 3 of the 4 were explicitly denied because of futility, and the thing that we are arguing about was not, like the magistrate judge said, didn't say that was.
It basically says you have no good excuse for why you're flip-flopping again.
Absolutely correct, and that's in contrast to the other 3 things that were denied explicitly for futility. So I don't think that it's fair to characterize this 4th one as being futile, or at least the magistrate judge didn't think so.
That's fair, but we often say, well, the district court got it right, even if he got it wrong, but for the wrong reason. But so the question is, notwithstanding what the court said, is there a basis on which this court can affirm based on futility?
I don't think so, Your Honor. I think what Mr. O'Boyle was saying earlier is that the specific complaint that leave to amend is about this sexual assault, and the video is covered up at that point. So there would be some dispute about what actually occurred there. So it wouldn't necessarily be futile, especially if you're amending the complaint at the beginning of the litigation.
Is there a dispute? I mean, you know, Mr. Morgan made much of the fact that Mr. Anderson did not file an affidavit, and I think with respect to the videotape and what actually happened affirmatively on the videotape, that's I think, an effective rebuttal to that. But is the lack of evidence enough to create a genuine issue of material fact? I mean, you're saying that the video was obscured. Okay, well, in that case, it seems incumbent upon the plaintiff to come forward and say, this is what happened.
Well, I think at that stage of the litigation, we weren't even at summary judgment at that point. I mean, he was trying to amend his original complaint. So I think at that was pre-discovery. So it would just be at a completely different stage, and the burdens would be much lower.
Right, so it's not futile because we predict that he might get summary judgment granted against him. It's only futile if we predict it would fail to state a claim on which relief could be granted or is defective for some other reason.
That's absolutely right. Another point I wanted to touch on very briefly is just, as you identified, Officer Ferguson and his counsel are essentially trying to flip Scott versus Harris on its head. We are not saying that Mr. Anderson deserves summary judgment here and that we must ignore Officer Ferguson's affidavit. Instead, what we are saying is that the video draws into question the narrative that he creates. It creates ambiguity here.
Well, and it provides some of its own narrative too, right? I mean, the video is affirmative evidence of some things.
Absolutely. I've watched this video close to 50 times, and what I see is a suspect on the ground, handcuffed, not really. I mean, there's no movement on there that could be characterized as resistant. And that's the last point I wanted to touch on, is that this court has never said that you need to be still as a statute in order to not be resisting arrest. I mean, small instinctual movements are okay under this court's excessive force analysis. And I think that this case, in terms of being clearly established, comfortably falls within the court's.
What case puts Mr. Ferguson on notice? Because he's making this argument regarding this qualified immunity argument. What puts him on notice that the pressure point technique was not acceptable?
Well, I think I would point to 4 cases, really. Jones versus Buchanan, Myers versus Baltimore County, Bailey versus Kennedy, and Kane. Now, none of those cases explicitly used the mandibular angle force technique, but I mean, they were involving punches and pushing into the ground. I mean, they were applying this rule against using unnecessary, gratuitous, disproportionate force against somebody who's secured, no longer a threat, and not resisting, and basically saying, it's not limited to the particular weapon you're using. It's not just about a taser or a kick or a punch. It's about using force, more than de minimis force, in that context against somebody.
Well, his argument would be proportional force to the movement, right?
I mean, it's hard for me to see, and I think what the upshot of these cases, that it's hard to see what sort of force, beyond just de minimis force, you can really use against somebody who's in handcuffs with multiple officers on the ground that can't really be characterized as resisting, at least how, construing the video as we must at this stage. For those reasons, we'll rest. Thank you, Your Honor.
Thank you, Mr. Valdez. I want to thank both counsel for their fine arguments here this morning. Mr. Morgan, you said you've been at this for 35 years. You're still going quite strong. 35 years from now, we hope, Mr. O'Boyle and Mr. Valdez, that we'll see you back here because you've done honor to your client and to your law school in representing, at least as amicus, the interests of Mr. Anderson, and we really appreciate your fine arguments here this morning. We'll come down and greet you and move on to our second case. Please be seated. Our second case is 24-1229, JW Aluminum Company versus Ace American Insurance Company. Mr. Bono?
Good morning. May it please the court. My name is Craig Bono, and I represent the appellants. I want to start with the questions that the court sent to us earlier in the week, because obviously that was top of the court's mind. So I think the answer to the first question on whether the endorsement effectively sort of carves out the relevance of condition M in the policy, I think the answer is yes. When there's an endorsement that is more narrow than the general policy itself or a clause within, then that endorsement supersedes the general statement in the policy, whatever that statement may be. Here, the endorsement is about supplements. The relevant piece of the policy is also about supplements. But if you look at the language of the two, the general statement in condition M talks about that supplement shall apply to all losses arising out of any one occurrence. That's the language. And that is what applies, generally speaking, unless an endorsement does something that would carve that down or narrow it in some way. The molten metal endorsement, which is the relevant one for purposes of this conversation, says that the supplement in that endorsement applies to direct physical loss or damage caused by heat from molten metal. So we have a couple things that are different. One, we don't have the term all losses. We have direct physical loss. And those are clearly different. All losses must mean something greater than direct physical loss. Otherwise, there was no reason to use the two different phrases. The second thing is, we're not talking about all losses that arise out of any one occurrence. We're talking about all losses that are caused by something very specific, heat from molten material. As a result, the molten metal endorsement is really what we should be looking at when we're going to determine the question that's really at issue here, which is, is there a reasonable interpretation of this policy and this endorsement that allows JW Aluminum, the plaintiffs below, to recover something greater than the supplement that is included in that molten metal endorsement? Right, and that's the question that was discussed at the district court. That's the question at issue here. Is there a construction of the policy that raises a reasonable inference or a reasonable interpretation that would allow for recovery?
So the second part of what we asked in the supplemental order was whether or not this issue that you're now talking about was forfeited because it wasn't the focus of the analysis below. So what's your position on that?
So, which is sort of where I was headed, which is the question below and the question here is, what is the proper construction of the molten metal endorsement in light of the rest of the policy, as the policy must be interpreted together? So what is the proper construction of this policy as regards to the supplement applied? That is the question that whether the endorsement supersedes is seeking to answer. That is the question that all the ambiguity arguments that we will get to later is seeking to answer. So no, it hasn't been forfeited because this court will allow variations on arguments as long as the fundamental question was presented below.
So where would you say, if I'm looking at the record, where would you say is the closest place in the district court this issue came to coming up?
So I guess it depends on what you mean by this issue. If you're talking about this
The question about how these two clauses relate to each other and whether one supersedes the other.
So the supersede, the specific
Yes.
issue
Where
of
is the closest place
superseding.
that came up?
That specific the doctrine of an endorsement superseding the policy itself, I don't believe it did come up. I don't.
Because that
it
seems like a
wasn't
pretty,
argued.
that seems like a pretty distinct argument. Because at a high level of generality, that argument is the relevant clause here is not X, it's Y. We're all looking at the wrong clause. That's a pretty discrete argument.
Well, so I wouldn't say that it didn't come up, though, and I think in our reply brief at note 7, there's a long list of various points within the record that all of the arguments were referenced, and so I think I don't have a recollection exactly in the record, but note 7 is where I would look to get the answer.
Can I just
But
take you a step back
oh,
about the thing that is constantly making my head hurt about this
Sure.
case? And that is like what the supplement actually does.
It's a great question.
Well, no, before we get to what the supplement means, I'm trying to figure out what the supplement does. And here's the question. So imagine this exact same policy. Every single thing about this policy is precisely the same, except the molten metal endorsement is out. The contract is in all other respects identical. Assume the same facts here, the same thing happened, and assume that we have stipulated that $35 million of bad stuff happened.
Okay.
Okay? In that scenario, does your client get nothing, or did they get $35 million?
So they get $35 million in that scenario, because what this endorsement does is, well, I guess it kind of depends. So in the $35 million that you just described, it would depend how that $35 million, what caused that $35 million.
Sorry, that $35 million of stuff was at least an approximate cause, both in a but-for causation and approximate cause. All $35 million is, as a matter of proximate cause under tort law, caused by the bad thing that happened here.
Right, so as you probably would guess, proximate cause under tort law, our position.
No, I understand that.
Not-
Let me rephrase. Any conceivable causation standard you want.
Okay,
it's
all right,
satisfied.
so let me just break down why this is important and why, to answer your question. I think, so the way that the buckets of damages in this scenario are separated matters to what would happen if the molten metal endorsement didn't
Was
exist.
gone, okay.
Right, so if the molten metal endorsement was, or if there was, let's say, that molten metal hit a bank of computers that were worth $10 million and melted those computers. Now, as the endorsement sits, that $10 million falls within the molten metal sublimit, right? If then a fire occurs and all the sort of the other things that happen in this, you have $25 million that would, in our view of the world, would fall outside of this sublimit. And so you would be able to recover all $35 million in that. If that computer was worth $25 million, you only get $10 million of that, and then you get the additional $10 million that happened because of the fire and the water stoppage and whatever. If you took out the molten metal endorsement, then you just get all 35. You don't even have to do the analysis to what damage occurred as a result of the heat from the molten metal hitting this computer bank in this example.
Right.
In our example, it's a de minimis amount of damage that was caused by the heat because what it landed on was a piece of metal.
So now I want to put the endorsement in.
Okay.
The molten metal endorsement's in, but now I'm going to make one other change. I'm going to delete the words by heat. The molten metal endorsement is verbatim the same. It just doesn't include the words by heat. What happens then?
So it's a really
So now it
good
just says
point.
caused by molten. It just says
Right.
caused by molten metal.
So now it's broader, theoretically, right? Because heat is out. But the way that the insurers want to read it and the way that the district court read it, I think that example gives you the same result. Because by heat was
You think the proper construction would be the same there, or you?
No,
think
no,
that
I
they
think that
it-
is what happened. So I think at the district court level,
Okay.
effectively, what the court did and what the insurers
Is read out
argued
the words by heat.
is they read out the words by heat. And so they made them equivalent to each other. I don't think there is a difference under that reasoning. Under our reasoning, the difference is by heat means the damage caused by the heat. So it's limited to the damage caused by the heat. It isn't damage caused by that molten metal. Now, what other damage could molten metal cause? I don't know. I don't know what all the hypotheticals of roads you could go down that would make it different, but it would certainly make it broader if you took heat out. The fact that heat is in has to narrow because molten already contemplates heat, right? Molten material is hot. That is what the word molten means.
Certainly
It means-
metal. There's no such thing as not hot molten metal.
That's right. You have to melt something in order to make it liquid, and that is hot. So that's already there. The fact that molten material, so if it was damage caused by molten material would have included heat without putting the word heat. So that they included the word heat means that you're cabining it now to specifically damage caused by heat, and that isn't what we have here.
So on that front, what is your best authority for so you say fire is not caused by heat. What is your best authority for that proposition? It strikes me that one of the very obvious consequences of really high heat is fire.
Well, so fire can be caused by heat, well, not in and of itself, right? Fire needs more than heat, right? It needs
Oxygen,
something
material,
to burn, it needs
yes.
oxygen, right? It's not just heat. Heat doesn't necessitate fire. But certainly you need it in order to have a fire. That is true, but I don't know that that matters, because the fact that one thing caused another thing that then caused a fire department to come and spray water that then caused...
Oh, no, the water becomes different, but I'm focusing on the heat caused the fire, and the fire itself caused some damage independent of the damage caused by the effort to put out the fire.
Right.
So I'm talking about damage caused by the fire.
Okay, damage caused by the fire, so that's the roof. So this comes back, and this case is really, it's a choose your own adventure, really, situation. But this really comes back to, is this an insuring clause or is it not an insuring clause? And that's important because that tells you how you're going to, this cause question that you keep asking,
Yeah.
right? Like, what does cause mean matters.
Right.
So if it's a tort, cause means something different than if it's an insuring clause, where Leslie would suggest, or states, that there's two things you look to determine what caused a damage. The first is the nearest efficient cause. If the nearest efficient cause, so the thing that happened nearest to the damage, if that thing is an insured peril, end of discussion, insurance exists. That's what we have here in your example. Fire cause is the nearest cause to the damage to the roof. That means that is a peril that is insured. That is a peril that is not part of that sublimit because it doesn't say heat and fire. It says heat, which is different. As a result, that's it. End of discussion. The fire and damages subsequent to the fire, or it's related to the fire, caused by the fire, are covered.
I'm curious to see how you handle the issue of your expert saying that this was all caused by, the fire was caused by the molten material explosion.
So it is true, and we don't dispute that. That's just what happened. The molten material was really hot, like 1,800 degrees or some absurd number. It's very hot. And when that hot thing hit what was aluminum dust fuel, basically, sitting on top of an I-beam in the presence of oxygen, that ignited. But that's a separate quote-unquote event, which is, again, is not a defined term in this policy, so we looked to just what the dictionary says for event. And while one definition is occurrence, which is circular because that means an occurrence equals an occurrence, the other definition is something that happens in one point in space-time. So the first event is when the pop happened in the tub, right? That is ejected this piece of aluminum. That's the event that led to the heat damage on the I-beam. Then, while it didn't take a long time for the fire to occur, some period of time elapsed. Then a fire started. That fire is what caused damage to the roof. It wasn't the heat from the aluminum that caused damage to the roof. It was the fire that happened later that caused damage to the roof. And then the fire department came, and then they put water on the fire, which caused an additional set of damages, which has happened later. Obviously,
So,
the fire department came later.
One other question about that. So when we look at the endorsements regarding the terrorism and I think they say movement of the earth, which I guess is earthquake and flooding, they explicitly says this clause about fire and water but it doesn't say it here.
Right, so in the definition of occurrence, so that, again, I'm going to choose your own adventure issue, but in the definition of occurrence, there are two definitions. So to the extent that the condition M matters because it has the term occurrence in it, and occurrence is then defined by the policies. But there are two definitions of occurrence. One that is general, that says losses that arise from one event, which is the one we've been talking about and the one that's relevant for our purposes for the molten metal endorsement. And then there's a separate definition for earth movement and flood, which I also guess is earthquakes. But that definition says occurrence is the sum of all losses that arise from damage caused by earth movement and flood, right? So that is a different thing, but there's two definitions. It must be different. So series of losses out of one event is the relevant for our purposes. Sum of all losses is relevant for earth movement. So as a result of sum of all losses that arise out of damages within the 72-hour period, which is what that definition says, that means it's broader and encompasses things like subsequent fires. So whenever they got to the endorsement for flood and earth movement, they had to carve out fires because their definition of occurrence contemplated it. They didn't need to do that for molten metal because their occurrence definition didn't contemplate anything other than the one event, which is the heat from molten metal escaping.
The district court in this case seemed to have melded the two sort of standards for liability with respect to causation, applied by and caused by. Is there a difference in your mind? And if so, should they be analyzed separately?
So applied by?
Yeah. Shall apply to all losses. Let me quote her. Consequently, the court finds that the $10 million sublimit applies because the loss and series of losses sustained by JWA, arose out of and were caused. So are those two different causation
Right, so
standards?
they are, and they're two different words, they mean two different things. And notably, the molten metal endorsement does not use the word arose out of. It solely says cause, whereas condition M says arising out of, which is broader, back to my original point, and why the more narrow language in the molten metal endorsement should govern. And cause implies something more direct, particularly in the molten metal endorsement, where it literally says direct physical harm caused by heat.
So apply those two standards in the way that you think they should be applied. What would be the result with respect to each of the things that happened in this case?
So whatever damage is caused to the I-beam by the molten material hitting it would be limited to $10 million. All subsequent damage that occurred as a result of fire, and then later as a result of water damage from the fire department, and then finally as a result of JWA deciding that they needed to shut off their utilities because there was natural gas pipelines in the wall by the fires and they didn't want the building to explode and kill all the emergency workers and the employees. So they shut those down, which meant the furnaces turned off, and so all of that molten metal cooled and then solidified in all of the machines, which meant that the machines were basically useless now.
You can't make this
that can't
stuff up,
happen.
can you?
I know. So all of those damages, which had separate events, those damages would not be subject to the sublimit and molten material endorsement.
All right, thank you.
Thank you.
Mr. Duffy?
Morning, Chief Judge Diaz, Judge Heitens, Judge Benjamin. May it please the court. Just as in the case BLG Enterprises versus First Financial Insurance Company, the interpretation rule that the endorsement controls has no application here. Just as in that case, there was no conflict with the endorsement, it did not provide a new grant of coverage that displaced an earlier exclusion. And that's the same thing here, Your Honor, but to the second point of what Your Honor's asked earlier, there's no question that any argument to the contrary has been waived. There's been no mention of any superseding. There's no argument that the damages are limited in some way other than this fabricated effort to try to sever the application of the molten material endorsement at the I-beam, which doesn't make any sense. It's not a reasonable interpretation. It would read out of the policy the molten material endorsement, the condition M, the occurrence language, because the molten material endorsement applies to an occurrence, which is a loss and series of losses. Your Honor asked earlier, Judge Heitens, what happens if the molten material endorsement weren't present at all?
Just gone.
The same thing happens because the sublimit is already there in the policy. The sublimit is listed among the sublimits in the declarations at JA 263.
This is the part where it just says like molten metals, $10 million.
Right.
But that's all, so literally, I don't want to spend too much time on that hypothetical contract because that's obviously not the contract we have. But if a contract literally was the same and it just said molten metal, $10 million with no explanation, you think that would be the same results here?
It would,
That
because
the
it
language,
limits.
wait, the language of this clause is literally irrelevant then? 'Cause
It's
it could
not
just-
irrelevant because it shows exactly that it applies here. This is talking about a molten material event that happened. This is what happened. It was the accidental discharge from equipment.
Can I ask you about this, I don't know how much it matters, but this exclusionary versus inclusionary clause? I'm reminded where the Supreme Court once said, in the world of silk purses and sow's ears, the Anti-Terrorism and Effective Death Penalty Act is not a silk purse of statutory drafting. That is how I would describe this insurance contract. Because it's a little bit weird to call it an exclusionary clause, given that the very first words of the clause are, this policy does insure against, blah, blah, blah. That sounds like granting coverage, not clawing back coverage.
Yeah, and thank you, Judge Heitens. I think that goes to my earlier point, that it is affirming, it is essentially summarizing the coverage that exists
I mean, that's one way to
already.
interpret it. The other way to interpret it is, but for this clause, it would not cover the thing I'm about to say. That's how I would normally write the words, this clause does insure. It's to extend coverage, not to contract coverage.
Well, the point about it's an all-risk policy, so there's no question that this risk is covered. In fact, it's saying, it's understood and agreed that
Why
the
do you need to
risk,
say things that are obvious?
because what it's doing, Your Honor, is it's setting up the actual exclusion that comes later.
Okay.
So the first sentence is defining, this is the coverage you have. It applies to the property damage in this case, in these instances, but it doesn't apply to these two specific things that follow that. That's where there's a conflict and a change, but it has nothing to do with what happened here. It's talking about damage to the actual
Okay, so
material.
can we go to the language of the actual clause? Because here's my concern. How does your argument and the district court's holding not delete the words direct and by heat from this provision?
Well,
Let me
direct,
rephrase. How would, in your view and in the district court's view, how would this mean anything differently whatsoever if we deleted the words direct and by heat?
I don't think it matters because
So those three words are all superfluous in your view?
they're not superfluous at all. It's explaining, Your Honor. It's a direct physical loss and damage is an insurance term of art. It is, and Ms. Grimes, the broker, admitted that. It's in the JA at 425. And what happened is and everyone agrees that direct means proximate, not remote. Both parties have agreed to that. Both parties cite the couch on insurance provision, which is 160.
But you think it would mean
148.60.
exactly the same thing if we deleted the word
Right,
direct?
because what it says, Your Honor, is direct includes a series of things that directly result. And so you're not splitting things at an I-beam. The direct includes that. It just doesn't include an intervening cause. That's what separates something from direct. And that's what couch, the very provision they cite and rely on, says later in that paragraph about this specific language.
If it's literally direct clause, direct and only caused by heat, then I wonder what this clause does. Because, admittedly, I'm not an expert in this industry or whatever, but like, what is the world in which heat and only heat, not fires caused by heat, not building collapse caused by, what is the world in which heat alone is going to plausibly cause more than $10 million in damages?
Right, heat. There are many consequences of heat, one of which is fire, the biggest one anyone would be worried about. But there are others. For example, it could have popped out and landed on the ground and melted the beam and the roof fell down. There was no fire, but it's still covered because it's a result of heat. Fire is an obvious concern that the underwriters and carriers wanted to avoid the risk of or limit the risk of with this provision. And that relates, Your Honor, to the causation question that y'all were asking earlier, is that this court in Valentine answered what happens in this situation, whether you're in distinguished Leslie, which is looking at an insuring clause to say, is this specific peril something that fits within a specific peril clause? We're not there here. This is all risks. It fits. It is within the ambit of the insurance policy. And then the question is, what are the limitations? And so the limitation...
I've heard your answer on the words direct, but why heat? Why in your view does this clause contain the words by heat? Because it seems like what you're really arguing it means is this sublimit applies to any damage that is caused by molten metal.
It is.
Well, no. So you're telling me we also should ignore those. In your view, what meaning do the words by heat add? And why, if they don't add any meaning, why doesn't this clause just say by molten metal?
That sentence is setting up the exclusion that follows that relates directly to that instance. So by heat is indicating that if something happened, we're not, that this, what escapes isn't covered, and the machinery, whatever malfunction machinery that might have caused it, isn't covered. That's taken out of even the sublimit. That's excluded entirely. That's what the molten material endorsement is doing. But the benefit of it here.
What do you mean taken, wait, if it's taken out of the sublimit, does that mean it goes back to, the first question I asked your friend on the other side, does that mean we go back to the 30, like the top limit, or does it mean it's not covered at all?
No, those two things, Your Honor, are directly excluded in that language. Does not cover. It says this policy does not cover. So those things aren't covered. Everything else is subjected to the sublimit. And in fact, the very thing that it's talking about is what happened here. And so there's no question that the sublimit applies. And then it applies, and you ask, what does it apply to? It applies to occurrences, which is a loss or series of losses from the direct physical loss and damage that we've talked about. And direct, again, means through, the direct means no intervening cause. And then when we're looking at the Valentine case again, that addresses this insuring clause and distinguishes Leslie, actually reversed the Honorable District Court below, saying you're relying on Leslie, and that's not an issue here, because in fact, the language Valentine this court used was when you're limiting, didn't just say exclusion, but if you're limiting the policy, what you're looking at is there any causal connection? In this court had certified a case to the South Carolina Supreme Court in Broach in the 80s that said, does there have to be any connection between an exclusion, facts that present an exclusion, and a loss? And the answer was, well, yeah, there's got to be something. You've got to tie it to what was the reasonable efforts that the carriers were trying to limit the exposure to.
So you've just teed up. So this is literally like a torts exam. And I mean, I know this is an insurance case, but this feels like a torts exam. So I have a couple hypos I want to ask you.
Yes, sir.
Say someone is driving by during the accident and they see the fire at the plant, and that causes them to crash their car into a pole. The pole falls over and causes damage to the plant. Do you think that the molten metal exclusion applies to the damage caused by the pole?
Does a molten metal? No, it does not. That's an
Why? But it was
intervening-
clearly in a butterfly effect, but for causation, it was clearly caused by the fire, by the discharge of molten metal, because the molten metal caused the fire caused the person to see the fire, seeing the fire caused the person to crash, which caused the pole to jump in. I mean, like, in a but-for causation, it's definitely but-for cause.
Well, Your Honor, the molten material endorsement wouldn't cover that because it's directly discussing the direct physical loss and damage, which would mean no intervening factor. And I'm presuming that somebody driving that way, there was negligent operation of the vehicle or doing something wrong to end up.
All right, great. Let's do a hypo where no one's being negligent at all. Say 3 months later, we find out that the water that was used to put out this fire, and you think that the damage caused by that water directly, you think is covered, right?
Yes, sir.
Okay. So now 3 months later, we discover that water caused mold to spread all throughout the building, that mold causes all kinds of damage. Think that's included?
Yes, sir, it is.
Okay, last question. Say when they go to sell this property like 20 years from now, it turns out that that mold has massively damaged the resale value of the building. Is that covered?
Is that covered by the sublimit?
Mm-hmm. Yeah, it turns out my building is worth a
Yeah.
lot less money because it's got a real mold problem
It is
now.
covered. And a case that applies a sublimit in that way is a Southern District of New York case, this National Railroad Passengers case, and it's about what the damage to the tunnels. So it was a flood sublimit, and it came in and said, okay, well, there were all these things that happened when the water was there, but when the water left, it left this chloride that caused other damages later. And the conclusion was the sublimit still applies because this is all the natural result of the flood coming in.
Okay, so if we intend this sublimit to cover stuff like that, I really don't understand why we have the words direct and by heat, because it really feels like what we're really interpreting to say is anything caused in a but-for sense, absent intervening and superseding negligence, is covered, which is, this is a weird way. If that's the rule one wants to adopt, this is a weird way to write that rule.
Your Honor, I understand that point, and there are a lot of hypotheticals that we could entertain to test it, but the benefit here is the sublimit describes exactly what happened in this instance. And so there's no question that it applies here.
Well, the question, and the reason you say no question is, it isn't even whether you're right or my hypotheticals are right about what this would mean. It's whether this is ambiguous, right? It's not even about what the correct meaning of this clause is. Like, what we would say sitting here we think is probably the right meaning. It's whether it's unambiguously the right meaning, right?
Well, I think it's when you look at the entire policy as a whole, as the district court did, and with, as Judge Benjamin pointed out, the undisputed facts that the molten material caused all of these losses. The plaintiff's experts say it. All you do is look at the policy, and when you look at the molten material endorsement, you look at the occurrence definition, and you look at condition M as a policy directs you to, it's applied the same way the district court did. And one of the other points, Your Honor, is that the things that you're raising in relating to the waiver argument, the waiver argument just isn't just important because it procedurally bars the court or the plaintiff from pressing it here. But at bottom, this court's exercise is trying to determine what the intent of the parties is. And if after years of litigation, depositions, rounds of briefing below and here, they haven't articulated that yet, clearly it wasn't the understanding of their client. They can't be articulating a interpretation of the contract that they'd never advanced before. That clearly couldn't be what they had in mind. That wasn't their intent in coming into this contract.
So I take your point about the pre-argument letter we got, but I want to take the issue about the direct versus indirect. You don't contest they preserve the direct versus indirect argument, right?
They do preserve that, the language of something being indirect, which is language of an exclusionary clause, which wouldn't make sense to add in this molten material endorsement because you're restating what the coverage is. If you added that there, you'd have ambiguity then about anything that's covered in that.
I just mean to the extent their argument is something that introduces ambiguity is the argument would be, I'm not saying you accept this argument, but if the argument is the thing that potentially introduces ambiguity is the fact that the molten metal exclusion contains the word direct. They preserve that argument, right?
Yes, they preserve that argument.
What about the argument, this heat versus fire? I mean, they do make that argument below.
Right, and Your Honor, I think that as the discussion with my colleague on the other side earlier demonstrated, I mean, heat it results in fire. And the point is, it is a direct result here that the heat from the molten material caused the fire. And it would be unnatural. You'd be reading several provisions out of the policy if you suggested that the only damage that gets covered by that is what happened on the beat. Because it's
Then why does this contract say the words by heat? Why doesn't it just say direct damage caused by molten metal? Why in the world are the words by heat? On your view, why in the world does this contract contain the words by heat?
Well, Your Honor, there are other ways you could look at it. If, let's say, an employee were anxious and started to run and slipped and fell on it, it wouldn't necessarily be covered because of a slip and fall. Or if it cooled and hardened, it's not heat at all, and someone tripped over it and got hurt, it's not covered by the heat portion of it. But what heat does do is it's broader than fire. As I mentioned earlier, if it pops out and melts a beam and the roof falls, it's covered. And then if it pops out and catches something on fire, it's covered. It's a broader expression.
Hold on. The trip and fall example doesn't work for you because this contract excludes personal injury, doesn't it?
I haven't looked at that, to be honest, Your Honor. Bodily injury is covered, but,
So that's that person's not, this doesn't exclude that because that's already excluded by a specific clause that says there's no coverage for bodily injury.
Okay, well, the idea is there are other ways that molten material, could cause damage. Your Honors, I go back, touch briefly again on the BLG case that Your Honors raised earlier, and hit on the point that that case involved a new definition and endorsement that was later. And similar to this one, the plaintiffs there argued that is a new grant of coverage that then displaces the exclusionary clause. And the court said, no, you need to read them all together. And when you read the provisions together, there's no necessary conflict. And in fact, that's not a new grant of coverage. It's just applying a new definition. So the specific exclusion doesn't apply there. The court here below had a molten material endorsement that was not a new grant of coverage. And that's the point is the all risk policy already provides the coverage. There's not a question of an insuring clause here. You have the coverage. And then the question is, how does the molten material endorsement affect that coverage? And what it does is it restates it. It says it's understood and agreed that this is what's here, and it introduces 2 exclusions that don't apply here. So there's no conflict with condition M. There's no conflict with the definition of occurrence. And so just as in that case, the district court here applied, interpreted the provisions together, which led to this result. Any other questions for the panel? I'd be happy to entertain.
Thank you very much.
Thank you.
Thank you.
So just very quickly, I just have a couple points. My colleague just said that fire was the biggest risk anyone would be worried about in regard to the molten metal endorsement, and that the insurers wanted to limit the risk of fire by that endorsement. That's what he said. But they used the word heat. The word fire was available for, if that is the biggest risk that they are worried about, that word is available. Leaving off the word heat is also available. Fire is a peril listed in this policy. They knew that fire was a thing that could exist in this policy. It's listed in the policy as one of the potential perils. They didn't use the word peril in the molten metal fire in the molten metal endorsement. And as a result, and they chose the word heat, and that choice has consequences. Whether they want to apparently run away from any consequence that the word heat has, that choice of that word matters. And it has to, and that's how contract construction works. So it's got to mean something. And it can't just mean fire, because fire means fire. And they didn't use fire.
Well, then can I ask you the same question I asked your friend on the other side, which is like, okay, but if it literally only means heat and that heat doesn't even include fire, what is the plausible world in which heat, qua heat, and only heat is likely to cause more than $10 million in damages?
So I don't know the answer, to be honest with you. It would depend. I suppose the question contemplates that the molten metal lands on something that is...
And that's simply by virtue of the heat. It's going
That
to cause
it-
more
that
than
it
10.
melts
Because after all,
something.
if the only reason you'd cap liability at $10 million is that you think that absent that cap, it might be more than $10 million, which means clearly whoever, this hypothetical drafter of this contract, was trying to do is to say, let's make sure that it doesn't go, that they don't have to pay more than 10, which has to mean that they're contemplating a scenario in which it might be more than 10. And again, I don't know a lot about this underlying stuff, but it just strikes me that it seems fairly obvious that what happened here is like heat causes fire, fire causes collapse, collapse causes, this all seems like well within the heartland of what could plausibly happen ex ante. And you could see why you'd want to limit the damages of that happening. I guess I've had a very hard time even hypothetically thinking of an example where just the heat would cause more than $10 million such that you need to cap liability for just the heat at 10.
So I used an example earlier of a very expensive bank of computers that got melted, maybe that. But I will say this, that whenever and I didn't really appreciate the size of the enterprise at JW Aluminum until we went there as part of this process, and I got to see these buildings and these machines, and they're enormous, like machines that are, like, takes up large parts of this room. And the amount of molten material that while in this instance, we're talking about a tiny droplet that popped out of a bin, right? The amount of molten material that they're dealing with is massive. Like if all of it got out, whatever, let's say that there was a hole or whatever happens, right? And it just spills out throughout the entire facility. That conceivably could cause hundreds of millions, maybe. It's a lot of aluminum that you have the potential to escape here. That's just not what happened in this particular instance. I want to go back to your questions related to whether this is an insuring clause or an exclusion clause, and why would you put this does insure to start a clause that then you ultimately exclude things with, if that is the insurance company's now view of this clause? It's a confusing clause, unquestionably, which really comes down to the fact that really no one is very clear about what this clause is doing, whether it's insuring and providing insurance, or whether it's limiting insurance, or whether it's excluding insurance, or if it's doing some combination of those things, comes down to the point on ambiguity, which is all that needs to exist here. If there's ambiguity in this clause, in the definition of occurrence, in condition M, in perils insured, and how that relates to the molten metal endorsement, which we didn't really even talk about, where peril is insured, lists sequence of events and damages that ultimately occur later down a sequence of events, that is insured by this policy. And then the molten metal endorsement talks about one of those sequence of events, but doesn't have the anti-concurrent causation cause clause that you see elsewhere, like the biological exclusion that does use an anti-concurrent cause clause. Altogether, in sum total, if there's ambiguity in any of this, Frankenstein's monster of an insurance policy, then we win. That is how it works when you're talking about applying insurance and seeking to limit the coverage of an insurance policy. If there's an ambiguity, the ambiguity goes in favor of the insureds and in favor of coverage. And we certainly have that at one of the 17 different levels that we talked about here today. On the last point on the supersedes and whether it was discussed below, I think that it's true that the word supersede or superseding was never stated and was probably not written. I think that's probably true. I didn't search for it specifically in the complete record, but I believe that to be true. But the concept that the molten metal endorsement is what we should be looking at and condition M is not what we should be looking at, that concept was absolutely discussed. Like, there's tons of briefing that's focused solely and entirely on molten metal endorsement and not on condition M. Certainly their argument has always been that condition M is important, but our argument certainly is partially great. If you look at condition M, ambiguity, we still win. But if you don't, if you just look at what the endorsement that is actually the relevant one here, we win that too. And that effectively incorporates that concept.
All right, thank you very much.
Thank you.
Appreciate the arguments of both counsel. In this case, we'll come down and greet you and move on to our third case. All right, be seated, please. Our third and final case is 24-4192, United States versus Gould. Mr. Coleman?
Good morning, Your Honors. Lex Coleman on behalf of James Gould. Mr. Gould was a 50-year-old widower. He had a son in middle school, a daughter is in her second year at WVU, worked 25 years as a pipeline contractor. Then, between then and when his wife died, his parents had died, the business went bankrupt, and he ended up with 4 involuntary commitments that were preliminary commitments in the sense West Virginia as a state has a preliminary finding. They're taken or admitted involuntarily to be both evaluated and treated, and then if someone feels anything else needs to be done, they move to the more formal proceeding and make a formal finding and can extend it beyond 5 days. My client never went beyond the preliminary admissions, but they definitely still met the 478.11 definition of what an involuntary commitment was under the ATF reg.
Is there anything in the record that shows whether or not there was a finding that he was no longer a danger to himself or to others when he was released?
No, sir, not at all. We argued the probable cause finding, and the district court acknowledged it in note 6 of the opinion, but no, the record's actually very thin on that. My client's position was he was released. The government never contested that, and there was never any documentation produced from the family or circuit court showing that he in fact had had a longer or a preliminary thing. But the law is, at least in West Virginia, is that, you know, they're not going to release him if they're still subject to danger to themselves or anyone else.
Can I take a step back? Your client pleaded guilty, right?
Yes, Your Honor.
Why doesn't that waive an as-applied? Everything you're saying, I mean, it could be atmospherics, totally fair. But if it's not just atmospherics, this sounds like an as-applied challenge, and why doesn't pleading guilty waive an as-applied challenge?
Under class, Your Honor.
Class says it doesn't waive a facial challenge. Where does class say it doesn't waive an as-applied challenge?
It doesn't say it does. If the same reasoning that would apply with a facial, why would it not apply with an as-applied?
Well, hypothetically. To litigate a facial challenge, I don't need to know all sorts of facts about the defendant. To litigate an as-applied challenge, I need to know a bunch of facts about the defendant, except when the defendant pleads guilty, we're not going to have a proceeding to determine all kinds of facts about the defendant. So it's one thing to say, like, I read class to say, I read your indictment, I agree that the conduct described in the indictment violates the statute, but I don't think you can constitutionally criminalize the conduct described in the indictment. That makes total sense to me. It seems weird to me, like the whole point about when you plead guilty is you say, we're not gonna look into your specific facts and circumstances because you're pleading guilty. And then to say, oh, it turns out actually as applied to my particular facts and circumstances, this is unconstitutional.
Then let me simplify that. We narrowed it down to a facial challenge before the district court.
Okay, well, so then
That
that
was
means
more background for the
then that
benefit
means
of the
that other than atmospherics, anything we're talking about this gentleman is irrelevant, right?
Correct.
Okay.
Again, that was more to introduce him, and I'll move
Okay,
on to
no,
the
fair.
merits of the argument. Just as there was no dispute with Rahimi, I don't think there was as far as Bruin's step 1 as to James Gould. And the application of G4, I think, is going to come down to a Bruin step 2, which has got multiple steps because of what happened between Heller, Bruin, and really Rahimi. The elephant in the room, I think, is going to be the presumptively lawful language in Heller, and what do we do with that? And I've put that in the briefing, but I can boil it down to several points. There was no G4 decision in this circuit between Heller and Rahimi. A bigger thing is that all congressional actions.
What about Canada? Why is this case not? Why is
I'll
it
tie that in. And I'm very happy you're here on this panel, Judge Heitens, both because I have a
I'll take that
question.
in the spirit in which I'm sure it's meant.
It is meant that way, yes, very much so. The Walters case from 1984, the U.S. Supreme Court, said that all congressional actions are presumptively lawful. And I didn't just come up with it myself, I heard it in the range oral argument with appellate counsel yesterday. And that's a very, very strong point. We do have this presumptively lawful language in Heller, and the discussions of points that were not necessary to the outcome of that decision, but that presumption applies to all congressional.
So we think that when the
pronouncements.
Supreme Court said in Heller, and then again in McDonald, and then again in Rahimi, that certain laws were presumptively unconstitutional, they were simply expressing the uncontroversial proposition that all laws are presumptively constitutional?
I think they were acknowledging that that's what we already presume based on.
No,
the
but
Supreme Court
they
precedent.
don't, but I mean, that reads out the fact that Heller and McDonald and Rahimi identified a subset of laws as presumptively constitutional. They did not say all firearms laws are presumptively constitutional. In fact,
That's true.
right, so they have to have meant something more than the background presumption that all laws are presumptively constitutional, because otherwise I don't know why they keep saying the same thing over and over again.
Well,
They don't say, for example, laws limiting possession of firearms by people who are left-handed are presumptively, that's not a real law, I take your point. But you know what I'm saying? Like there's lots of other categories of laws that regulate firearms that Heller and McDonald and Rahimi don't go out of their way to say are presumptively constitutional.
Well, obviously it was before the court, and it was.
They
true
don't say
there.
that bans on high-capacity rifles are presumptively constitutional, for example.
Well, I go to Canada and looking at Rahimi, and that's a question I had for you. You had noted that Rahimi reiterated prohibitions on the possession of firearms by felons are presumptively lawful. And you cite Heller. When I look at Rahimi, I've got Justice Roberts recognizing when Rahimi argued, hey, you've got a categorical prohibition against regulating guns in the home. And that's not true, Rahimi, because look at the Heller dicta. That doesn't apply. The only other justice in Rahimi that talks about the presumptively lawful language in Heller is Kavanaugh's big discussion of how history is so much better metric than policy. And that was in Rahimi.
What about plurality in McDonald?
Well, that was before Bruin. And this is
So
how
this goes back to the argument that everything that happened before Bruin is basically we turn over the table and nothing before Bruin matters.
I don't agree with that,
Okay,
because the Supreme Court has said that.
right. Rahimi rejects that view pretty strongly.
Correct. So we're down to functionally what do we got, and it's harmonizing is better, because I don't think one excludes the other. The big thing about Bruin, I see, is it requires an historical analysis. If we go with the presumptively lawful language, that gets rid of a facial challenge, it's out the door.
Can I ask you to address, can I just ask you to address Judge Strauss's opinion for the Eighth Circuit and why that doesn't just answer, why is Judge Strauss wrong?
I'm sorry, you'll have, please
It's the Eighth
summarize.
Circuit rejects a constitutional challenge to this precise statute.
I think if it rejected a facial challenge,
Yeah.
it would be because they
And what-
say it has to apply in some situation. Correct?
Right. But I guess I'm saying is there is a published opinion by one of our sister circuits that rejects a facial challenge to this precise statute. And I'm asking why the reasons they give are wrong.
I'm sorry, you'll have to remind me.
Okay,
I've
so
looked
one
at
of the
a
things they
ton
rely on at history and tradition is there is, again, this is just a reality in the world in which we're having to do this. There is a history and tradition of taking people, at least some people who have mental illness, and just locking them up. And before the 1960s, we often did that without very much due process at all. But the court says there's a history and tradition of doing that. They also analogize mental illness. They say the way people would have thought at the time of the Second Amendment, you could think of mental illness as a form of temporary insanity. They analogize to cases involving people who are impaired by substances such as alcohol or drugs, and they say there's a history and tradition of saying people who are intoxicated can't have firearms, and they say that is a sufficiently close analogy under the world we're doing. They say that. They literally reject a facial challenge to this precise statute.
True. And the language of the statute, we got two different things with Heller. Heller uses mentally ill. This statute does something different and doesn't even define it, and then it takes an ATF reg to define it. The historical tradition that is consistent, even going back to the time of the founding, is with acute incidents of mental illness. They didn't treat mental illness as a permanent malady. It didn't make the assumption that G4 makes, is that if you ever are involuntarily committed, you're unfit for the rest of the future no matter what. That's what G4 does. The government, Judge Sutton put it in his concurrence in Tyler, that you're using a sky-high generalization to do a skin-deep assumption
Well,
based on mental
but
illness.
that's subject to the qualification that at least in some jurisdictions, you're able to prove otherwise, right? Your fitness to
My problem with G4 is denying it to begin with. You've got the
Right, but
order
you just
to
said,
commit.
what you said was, once that finding is made, you're unfit permanently to, have guns in your possession.
That's
And
what the
not-
statute, yes, sir.
Well, except for the fact that in a number of jurisdictions, you can petition otherwise, right? So does that make a difference?
Well, let me go through the history of that then. We've got 1986, the Firearm Owners Protection Act let us try and do something under 18 U.S.C. 925C. But by 1992, that was defunded and couldn't be used at all. Then we have the Virginia check shooting, and they want to improve the National Instant Criminal Background Check System. I don't know why they just call it NICS. And that was the 2000 amendments with the grant program that's in Title 34. The 4,000, 901 through 915, 916 per the code. That is a grant system where 3 to 10% of that goes to relieving firearm disabilities. If states will set it up and do it statutorily, it does not require them to do it, nor does it require them to restore anything. It's got a big if, but, which to me really mirrors the you've got to prove you have a right to have a gun that was the whole shall issue, may issue distinction in Bruin, and really tracks that it's more of a may issue when you get into the ones that adopted it. Congress could have, and why it didn't, mandated that the states, hey, you guys put up a restoration thing. But it's so inconsistent throughout the code. The amendments to the NICS apply to federal agencies as well as state. In the federal, if you are committed and you do the treatment and you are released, they don't report the record. They're not required to. In the states, they still are trying to get it in. So this whole system is inconsistent.
Right, but you seem to be sort of toggling back and forth between an as-applied and facial challenge. The question is this statute in its, most extreme or most favorable application by the government constitutional, notwithstanding that there may be nuances across jurisdictions and across laws that might warrant a different result in a different case?
The difference is in the two clauses of the statute of G4. A mental defective is a finding, and if you look at it, you got to be a mental incompetent, can't manage your own affairs. It's something that is not a temporary thing. It's a finding that exists until it doesn't exist. Whereas with the involuntary commitment, you go in because there's whether it's probable cause or it's clear and convincing evidence that you're a danger to yourself, you're a danger to somebody else. The mechanisms and procedures are there to keep you, and they do keep you until they presume you are not. And then you're released. That someone's deprived of a gun while they're under a commitment order and in a mental hospital, that makes plenty of sense. But that's not the language of the statute. The statute is in the past tense, have been subject to a commitment order. That order doesn't end until someone is deemed to no longer be a danger to themselves or the community. And yet we're depriving them lifelong without some potential thing down the road, like the May-Shall issue.
Mr. Cullen,
the
first of all,
right to have a gun.
I owe you an apology because my staff pointed this out. As I suspect you, have a lot of Second Amendment challenges to federal laws in my head, and the case I cited to you that you were not, it was not about G4. So I'm also going to spare you the need to point out a post-argument letter that I was wrong about what that case was about. That case was about G3, not
Yes.
G4. That's my fault. I'm sorry
And that's
about
what
that.
threw me, and I
Nope,
remember
nope,
the
that is-
discussion.
That's 100% my fault. But could I ask you to follow up on the Chief's point, which is like, a lot of what you were just saying strikes me as, wow, there probably are some people who might have some pretty compelling as-applied challenges to this statute, right? The example we sort of workshopped is, like, imagine someone who was, when they were in college, was involuntarily committed because they got extremely intoxicated one night, and it's 35 years later, and they've never had any mental health problems since then, and they've been a model upstanding citizen, and heck, maybe they got a security clearance from the FBI or something. Like, sure, saying that person can't lawfully possess a firearm might raise some really hard as-applied challenges. It's not clear, though, why there's no one that this statute can be constitutionally applied to. What's the
Again,
response
it
to that?
has to do with the presumption that the mental state is the same after they're released at the time of commitment. And it is the mental state at the time of commitment that makes them dangerous, and we should take the gun away. That has historical support, whether someone is totally drunk and they take the gun away in the saloon, or they're a raving loon out in the street who the constable takes in and they lock up until the spell is over. And at the time of the founding, mental health was much more temporary than it's diagnosed with now and understood that way, and rights applied. And we're not talking about an answer. I'm really, really close to my red light.
No, your red light is on.
Sir?
Your red light is on.
Oh, I'm running over.
Yeah.
The glasses help. As to why it wouldn't apply in any of the context, it's the structure of the statute and how it defines the disability that makes it unfairly inapplicable and inconsistently applicable. I know that sounds as applied. It's not. It's facial across the board. Can Congress come up with something that would address the danger consistent with the Second Amendment, Bruin and Rahimi? Yes, it can. There's an historical tradition that would support it. It's just that G4 is not it.
Thank you very much.
Yes, sir. Thank you.
Mr. Price?
May it please the court, my name is Gabe Price, and I'm representing the United States in this case. 18 U.S.C. 922 G4 is constitutional for two main purposes, or two main reasons. First is the presumptive lawfulness language that the Supreme Court has repeatedly stated throughout all of the Second Amendment opinions over the last decade. And second, the history and tradition of this nation have the underlying principle that those that have been found to pose a danger to society or others can be constitutionally disarmed. And that's the underlying principle from
How do
Rahimi.
you deal with, so Let me preface, I know that we don't read Supreme Court opinions like statutes. The Supreme Court has told us not to read Supreme Court opinions like statutes. I can assume that you've already given me that response. But what the court has said is you can disarm felons and the mentally, there's a history and tradition of disarming long-standing felons and the mentally ill. Like, sort of once a felon, always a felon, that totally makes, a felon is a person who has been convicted of a felony. That's what the definition of a felon is. The mentally ill sounds like a person who is presently mentally ill. And I take Mr. Coleman's point to be maybe the first clause of this can be plausibly thought as applying to the mentally ill. But saying any person who has ever been involuntarily committed is irrebuttably presumed to be mentally ill for the rest of their life does seem odd.
I understand Your Honor's point. However, in a facial challenge, I think that looking at the statute as a whole, that there would be a subset of those that are being involuntarily committed that are mentally ill as well.
Okay,
So-
but that's an important concession because you raised in your brief the John Hinckley example, and they come back and say the John Hinckley example doesn't work because John Hinckley is covered by what I'll call the first clause of 924 G4, right?
And I would disagree with that characterization a little bit. I think he's covered under both clauses because.
But
he
you
was
agree,
also
I guess what I'll say is,
involuntarily
there doesn't seem to be any reason that 924 G4 couldn't be further subdivided into Romanet 1 and Romanet 2, Romanet 1 being people who've been adjudicated mentally incompetent, Romanet 2 being people who have been ever committed, right? And I guess what I'm saying is, the government is not arguing that he can't make a facial challenge just to what I'm calling Clause 2, right?
I don't know and this wasn't briefed as far as whether 922 G4 can be subdivided based on the or within those.
Well,
two
for purposes of
subsections.
a facial constitutional challenge.
Yeah, it may be.
I guess what I'm saying is the fact that it strikes me, Mr. Coleman agrees with you, that there are certainly instances where this can be constitutionally applied to people who've been adjudicated mentally incompetent. But that does not in and of itself end this facial challenge, right?
I think that in this scenario, I think that would end the facial challenge based on the fact that you can still be mentally ill when you're being involuntarily committed as well. So the involuntary commitment does have some application in which the mentally ill would be committed to the mental hospital. And it's that finding of dangerousness along with the mental illness that would raise the presumption language.
I really don't understand that answer at all. I guess what I'm saying is, just because, I'm not in a strong sense making Mr. Coleman conceding this, but let's say Mr. Coleman concedes, there's at least one person on earth who can be constitutionally disarmed because they have been adjudicated mentally incompetent and their competency has not been deemed restored. That does not mean that this client cannot raise a facial challenge just to the part of the statute that says, simply because I've ever been committed is not a valid basis for depriving me of my Second Amendment rights for the rest of my life.
Yes, I think Your Honor's right there, where there may be a section where the mental defective part, first part of the statute.
Could be facially
could be
unconstitutional.
Well, I think that's facially constitutional under the
But,
presumption.
but that, sorry, I know you believe that it's facially
Yes.
constitutional. I'm just saying, conceptually speaking, the answer could be different when it comes, do you see what I'm saying? You can subdivide, there's no rule that says if you're gonna facially challenge 922 G4, you have to show the entirety of 922 G4 as facially unconstitutional.
Yes, I think I understand what Your Honor is
Okay.
asking now. Yes, you can make a separate facial challenge to the first prong
Thank you.
and the second prongs. I just don't feel that.
That he
based-
has, right.
That he has in this.
Totally fair.
In this section. This court recently, with both Your Honors on the Canada opinion, talked about that presumptive language with felons. And that, again, that presumptive language from the Supreme Court, although maybe dicta, it really was given substantial deference by this court. And I think continuing to give it substantial deference.
Well, not just in Canada, but we've got a couple of recent banks that also do that too, right?
The Maryland shall issue case, which looked at the dicta of the shall issue regime, also said that that this court gives substantial, if not near controlling deference to Supreme Court.
But what does
dicta.
that language mean in the context of someone who's been voluntarily committed for mental illness? And of course, you know, I'm certainly not a doctor, but my understanding of mental illness is something that you confront over the course of your lifetime. And in the case of Mr. Gould, it appears that he'd had his ups and downs, had been committed 4 separate times. And as Mr. Coleman indicates, each time he had been released, presumably because he had been treated and was now in a much better state than he was when he went in. And so the question is, does a presumption mean that apply only to those who are at the moment in time a danger to themselves or others? Or does it apply simply to the label of suffering under a mental illness? Because if that's the case, I suspect there are a good number of people in this courtroom who might be judged unable to have a gun.
And I agree, mental illness is something that is a lifelong
Right.
struggle. And I think when we're talking about the language that the Supreme Court has used in the presumptive lawfulness of mental ill, they had to have been talking about 922G4. And
Meaning
when-
someone who's been voluntarily committed.
I believe that would be covered by what they said, and then
Right, but
the,
Mr. Coltman's argument is that speaks in the past tense, and presumably if someone is no longer voluntarily committed, the state has made some showing, or has made a determination that he or she is no longer a danger to himself or others. Now, there may be a distinction between someone no longer being a danger to himself or others and someone who might pose a danger if he or she had a firearm. Maybe that's the distinction that we.
and I think that is a distinction. And in cases where you have somebody who has specifically been found to be a danger to others that led to that involuntary commitment, that is what leads to the deprivation of the ability to possess a firearm. Unlike Bruin, and Bruin really talked about, you start off with the presumption that you're not entitled to a firearm unless you have the special need requirement met in your licensing. Here, everyone starts off with the ability to possess the firearm. It's once that finding is made under 922G4 that you then lose the ability to possess a firearm. And you can regain that under West Virginia law, I believe in my brief I cited 33 different states have laws for the ability to have that showing that you are no longer a danger.
Right, so, take Mr. Rahimi in the domestic violence order case. If there ever was someone who probably should be deprived of handguns for a long time, if not permanently, it would seem to be him. But yet, in that case, assuming he had not possessed a weapon during the time that the order was in place, if he had simply waited until the end of the expiration of the order, by operation of law, assuming there were no other disabilities to his having a handgun, he would have been entitled, under the Second Amendment, right, to carry a weapon.
Absolutely.
The difference here is the onus is being put on the petitioner to prove his case, to show otherwise.
Yes, the onus is put on the petitioner to show that he's no longer a danger. And
Isn't that
think-
problematic under the Second Amendment?
I don't believe so, Your Honor. The Second Amendment, in the Supreme Court cases, they have allowed or looked at what is the tradition and history of the Second Amendment, what is the tradition of the disarming, and not looking at a specific historical twin, but what is the underlying principle? And the underlying principle that Rahimi identified is that those that have been found to be a danger to others or to society can be constitutionally disarmed. And in this case, under a G4 analysis, they have that finding, so they can be constitutionally disarmed. How it comes about as far as regaining their ability to possess the firearm, whether it be automatic, similar to the way it was in G8, or whether they have to have that showing themselves, would not necessarily affect the facial constitutionality of the statute. That may be an as-applied statute where, let's say somebody, I think the hypothetical was 35 years ago, got intoxicated, got involuntarily committed, has not had any problems for 35 years. They go into court and ask, I want to restore my Second Amendment gun rights. They have an expert, a doctor that says they are no longer a danger, and the court still says no. At that point, you have, I think, a very good as-applied challenge to the statute. But when we're looking at the facial constitutionality of the statute, we have to look at whether this statute, whether there's any constitutional application of this statute. And so looking at that, whether the onus is on the person to regain their rights or whether it's automatic ending, I don't think is really an important analysis of the historical tradition within the Second Amendment rights. Turning to what Rahimi really says. And, Rahimi says that, again, the underlying basis being looking at those who pose a danger to others can be constitutionally disarmed. And they said that the Second Amendment, they didn't suggest that the Second Amendment prohibits that Congress is not allowed to create classes of dangerousness within their legislation. they were very clear that Rahimi was not limited to those only that have been found to pose a danger. But the Supreme Court did find that those who pose a danger, such as Rahimi in a G8 situation, that those statutes would be constitutional. Under G4, we have the similar rationale, the similar basis. We have similar historical laws, such as the surety laws, the going arm laws. We have, as Your Honor mentioned, laws that
But aren't the, I mean, the problem becomes, it's the proxy issue. I take your point that Rahimi does not say dangerousness and only dangerousness, although I don't know that Rahimi also doesn't say, I think Rahimi leaves open the question about whether things beyond dangerousness are good enough. But Rahimi does very clearly say dangerousness is good enough. But then the question is whether the thing the legislature has chosen is a good enough representation or proxy for dangerousness. And I mean, by that measure, this seems like a harder case than Rahimi in that sense, because in Rahimi, it's is there a good enough proxy for dangerousness? Well, someone found you were dangerous kind of recently. That's a pretty good proxy for dangerous, putting aside the due process issues that were sort of motivating some of the concerns in Rahimi. But assuming that that initial proceeding was done in a due processy way, the fact that there's been a finding you're dangerous is a pretty good proxy for the fact that you're dangerous, right? Whereas here, we're using the fact that the fact that you've been adjudicated mentally incompetent and your competence hasn't been restored seems like probably a pretty good proxy for dangerousness. The fact that you've ever been involuntarily committed in your life, how good a proxy for dangerousness is that?
Well, and I think it's not a proxy, I guess, when we're talking about proxy for dangerousness, in the involuntary commitment in which the statute operates, there has to be that finding of dangerousness.
Well, there was a finding at some point in the past, but it might be 35 years later now.
And it might be 6 months later. So, and that's where my argument as to a facial challenge
as
versus
applied.
as applied. Rahimi, it's
To a person who was released from a mental institution literally yesterday, and I could imagine released. So when the folks are deciding whether to release people from a mental institution where they've been involuntarily committed, the chief is, I think, quite right that you have to decide, are they dangerous? My hypothesis would be that the mental health professionals at those facilities would be, well, this is a person who, when released, is not going to be allowed to have firearms. And if you were to tell me that this is a person who is allowed to have firearms, I might make a different decision about whether to release them. Is that one possibility?
I think that's absolutely a possibility, and I think that's why in looking at this on the facial challenge side, you have to consider all of those possibilities. You have to consider whether and there's nothing in the record as to why Mr. Gould was released in this case, and being a facial challenge, that's not surprising.
To use the John Hinckley example, it strikes me as almost impossible to imagine that the people who decided to release John Hinckley did not take into effect that it would be illegal for him to have a gun after he was released.
I agree with Your Honor. I think that's a fair point, and I think that supports the argument that it is facially constitutional because there are some aspects where that finding of dangerousness, even after release, would still not dissipate. And because it hasn't dissipated, and there is the procedure that there is a finding, there can be a finding of non-dangerousness after the fact, supports the inference that the finding of dangerousness does continue until that subsequent finding is made for purposes of the Second Amendment. Really looking at the history and tradition and the different laws, and I know Your Honor brought up, I think it was Beasley out of the Eighth Circuit, which is cited in my brief for the G3 case. They really do rely on G4 and the historical analysis behind what makes G4 constitutional. And they were looking at the distinctions.
You're doing a very nice job of making me feel better about getting confused.
And I understand why you got confused, because the majority of that opinion was about G4. It really delved into the history behind that. And I think Beasley is one of the best cases for the government in this scenario that show why G4 is constitutional with the historical basis. Based on all of the language the Supreme Court has said, giving presumptive lawfulness to the prohibition of firearm possession by those that are mentally ill, and based on the historical tradition of disarming those that pose a danger to others, the government would ask that this court affirm the district court's judgment in this case.
Thank you very much.
Thank you.
Mr. Coleman, you've got some rebuttal time.
Yes, sir, thank you. So quick points that in our questioning I want to remind the court, Bruin requires an historical analysis, a consultation of history. If we, as courts, litigants, the government, just go with the presumptively lawful finding, we don't just relieve the government of the burden that Bruin and Rahimi put on them. We relieve the court. There's been no historical analysis, certainly by this court, by the Supreme Court, going into either G1 or G4 or convicted felons. Well, this court has, obviously, but you know what I'm saying. So that is important, is that if we got to be real careful with it, as Bruin and Rahimi, it's not that they displaced everything before, but you're right, it's evolved. They've acknowledged it's evolved. We're not overturning it, but it's changing it. Rahimi pretty much got rid of the whole distinctly similar analysis that Judge Thomas started with, requiring a really tight fit with historical analogs, to really expanding on the relevantly similar where we are now. Even applying that to either Veazey's precedents or the government's, they just don't fit that, not G4.
So your friend on the other side suggested that when the court in Heller said longstanding prohibitions on firearms by the mentally ill, they must have been thinking about G4. What is your response to that?
I've studied Justice Scalia for years, and I never could read his mind. I have a
Well,
hard...
what do you think they might have been? I guess the only thing that strikes me as totally inadmissible is that they didn't have anything in mind. So the question is, what do you think they could plausibly have been referring to?
When I saw the play between Justice Scalia and Stevens in that opinion, and they're going back and forth, I saw Justice Scalia focusing on honing in on the individual right and taking some, not very deep, responses to the attacks to get that core holding through. Heller was in 2008. The Gun Control Act is 1968. That's only 40 years. You add now up through Rahimi, that's 56.
Right.
Could that really have been longstanding?
But they said it.
He did say it, and I took it at face value as an advocate and a lawyer, going, wow, he's Justice Scalia, he knows something I don't, until I started researching it. And that lends credence more to the criticisms that this is not the holding of the court, and the bigger guidance is at the end of the opinion when he says, it's our first foray into this, we don't presume to answer all the questions, there'll be time to expand upon the historical basis of this later. And that's what we're doing.
And so what do we do with the historical tradition, as it were, that, again, this is probably an overgeneralization, but like there's a sense in which for a long time, again, what we did when people had serious mental illness, again, this is not good and we don't do this anymore by and large, and it's a good thing that we don't do this anymore. We just shoved them somewhere and threw away the key and just left them there for the rest of their lives. I mean, we did that, right?
I know we did it in early parts of the 20th century, certainly after the Depression. It was much more private and in-home. You hear the stories. I grew up in the South. There was somebody in the family had a spell, or there was Aunt Matilda.
And I guess my
premise
premise here is that when we did that to people, they were not allowed to have firearms where we put them, right?
Not where we put them, no.
And I guess what I'll say is, and now you could make the argument that the greater doesn't include the lesser, except Rahimi endorses a version of the greater includes the lesser, right? If you can do the worst thing, you can do the lesser thing. Like,
Well-
that's a part of the court, that's a move the court makes in Rahimi.
Well, Rahimi is really focusing on the temporary, and if that were true, it would have been so easy to go to the bigger to justify this without having to grab from a civil and a criminal regime to justify a temporary ban that you don't even need an order to end. If the order expires, so does the disability. And it's kind of like Judge Niemeyer said about drugs back in Carter in 2012. Stop using drugs and you can have a gun. So here we are with this, the commitment order ends, yet this statute is permanent. We might have some things we talk about where you could be, but until you get it, you're basically, as a citizen, who's supposed to have the right for self-defense, having to push another rock up a hill to hopefully you get it back, when frankly you shouldn't have lost it in the first place, except when you were locked up. And the statute, the way it's structured, speaks to after. And if they're releasing you, someone's decided, who's qualified, be it a judge or a doctor, that you're no longer a danger to yourself or anyone else. And getting to John Hinckley, he was committed for 25 years I don't know that whether he could have a gun or not factored into any of it. He was heavily supervised, he did his guitar tour. And I would think after that period of time, whether he shot President Reagan originally or not, that the doctors were satisfied he was not a danger, or they wouldn't even have brought it up. So my time is up. I appreciate your
Thank you,
attention.
Mr. Gould. Appreciate the arguments by both counsel in this case. We'll come down and greet you. We do have some high school students in the audience, and we are going to talk to them after we're done. But unfortunately, unlike the younger people in the audience, Mother Nature is calling for me. And so we're going to take a 5-minute recess, and then we'll come back and chat with you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.